Hey everyone, this is Finance Meets Real Estate. So we meet here every Tuesday, 6:30 p.m. Eastern Standard Time. We have amazing guests every week, just like our guest here tonight. Tonight we are going to talk about a very interesting topic, asset protection and tax planning, essentially integrating the two together. Riley, he was a guest actually at this webinar a couple of months ago, and I noticed that he had a pretty interesting slide and like pretty interesting presentation as to what his company does as far as asset protection and tax planning as well. So he's gonna discuss this topic. So he is an investor. And his firm helps to reduce taxes and liability exposure for entrepreneurs. In his career, he coordinated efforts needed to protect millions of dollars of real estate, and has been a consultant to multiple investment firms and small to mid-sized companies. So let's kind of jump into the topic. So Riley, if you would like to introduce yourself as well, I mean, I give like some introduction, but so we'll have a kind of a Q&A, some Q&A / presentation, and then more Q&A at the end. So if you guys have any questions, feel free to speak up, or you can put your question on the chat as well. So yeah, with that, Riley, I'm gonna pass the floor on to you, and I made sure that you can share your screen, so you're able to do that.
Awesome, thanks. Yeah, it's good to be here. Essentially, I started this firm to help my investors and my multifamily deals, and it started to kind of grow, and I started to realize the need for integrated CPAs and attorneys, because it's kind of an epidemic right now. Let me just let's see. Pull up my website, and I want to show you guys some stuff that some statistics that are a little bit alarming for entrepreneurs in general. But basically, you can tell the risk that a insurance company is taking on because of, let's see. It says it's having a hard time sharing the screen.
On my end, it's permitted. You should be able to do it, but I'm not sure. It should be working okay. Yeah, I think it's starting.
Oh, there we go.
Yeah, I can see your screen.
Cool. So let me just go to your. So you're under attack. I mean, that's obviously my opinion, but the property and casualty insurance industry, their losses have doubled in the last 10 years, but the number of premiums is, I mean it's going up each year, maybe 10% each year, but to have double the losses is insane. Each new person you have sign up is generating more revenue, and in my opinion, it's because the number of liability related lawsuits is going up dramatically, and this is almost 100% increase. So the number of liability claims made in the court system in the last 12 months is almost doubled, which is insane. And this statistic here is based on nuclear jury verdicts, which is like the nuclear option that basically destroys a business, which is a judgment of over $10 million in damages. So the lawsuits, obviously they're happening, and the old thought that you need to be doing something wrong in order for a lawsuit to be filed against you is completely false now. This is showing that the justice system is being used as a tool to get paid more and more often than it is to be use to get justice, which is really frustrating to me. And what's more frustrating is when you try to solve this problem by going to an asset protection attorney, they'll set you up. They'll put as many protections in place as you want, but those asset protection attorneys are not trained on taxes. And so they'll set something up and it has some severely negative tax implications for the business owner. And vice versa, someone will go to their accountant. I think most entrepreneurs, real estate investors included, will go to their accountant to have them set up the structures for their business. And at that point, the accountant is essentially acting as a document preparer. They're not actually, able to give you the legal advice necessary to really set up those entities. And so they're just acting as a proxy for you to file those documents. And that's pretty much all they do is file them for you. But people don't really realize that. And I'd say actually probably most accountants don't really realize that, of how inadequate that protection ends up being. And the accountant will help you basically follow what's in the letter of the law, which is no commingling of funds. And, you need to have your paperwork initially filed, your articles of incorporation or operation. But the thing on the back end that people don't really get to see, except for the attorneys, is what a jury does when they're deciding if they're going to penetrate your corporate veil protection. And the rule of thumb that they use is very different than what is written in the law and what you can find on these, government websites, or what your accountant will tell you. And they're looking at whether or not an LLC is following corporate formalities, which normally only S corporations and C corporations are supposed to follow corporate formalities. But in a lot of states, if an LLC isn't, that can be enough to penetrate the protection that it's supposed to offer. And I won't go, too far into that and what other ways the corporate veil can be pierced in the states and everything. It's kind of a rabbit hole. But suffice it to say, there's a lot of people out there that are not as protected as they should be and as they could be, just because it's seen as being really expensive. So here is basically a hypothetical scenario. We work with a lot of short-term rental investors. This is a setup for a short-term rental investor, where their short-term rental is held in a holding company, which is leased to a C corporation and then is subleased to the tenant. That basically draws the profits from the tenant through the C corporation into the holding company, and all the C corporation's revenue is being paid to that holding company. And so there's no double taxation. In fact, a lot of times the C corp is not even taxed at all, just because it doesn't carry a profit. One of the reasons we use those C corporations, because it does offer slightly better asset protection, because it's based on federal law instead of state. But it also has more deductions available to it than an LLC or an S corp. And then just in this particular scenario, these holding companies are set up as pass-through entities. So is the Wyoming LLC. Profits pass straight to the client without them having to file returns for every single entity involved. And they basically are controlling the C corporation through a family trust. And that just is mostly for anonymity. Usually that trust is going to be revocable, which doesn't really offer much asset protection. And one of the reasons we do that is because we don't hold anything in the C corporation. Everything that it's doing is with subleased assets that it doesn't technically own. And so that shields this holding company where the assets actually are from a lot of the liability. So that's our approach. We're trying to protect the assets of our clients as best as we possibly can. That's our first priority. And after we set that up, we go through with the accountant and we make sure that everything is going to be really simple. You're not filing dozens of tax returns, and that you're getting a better tax benefit than you had before you set up the structure. And the combination of those two things is really pivotal, and it has saved a lot of our clients tons of expenses and headaches. I mean, part of it is because they're saving money in taxes or they're not getting sued. But the other part is if you want to end up with this type of a structure, a lot of times the client will hire the asset protection attorney. Everything will be good. They go to the accountant and the accountant says, no, don't do that, that, and that. And they change a bunch of things. Then you go back to the asset protection attorney and you kind of play this game of monkey in the middle. And it ends up being really expensive, and you're paying these professionals to undo what you already paid another professional to do, and it just doesn't make any sense. So I mean that's our initial approach. There's a lot more to it than that, but I guess I'll hold off for some questions. I don't want to bore you guys too much. This is an exciting topic for me, but for most people it's pretty dry. It doesn't help that I've got a monotone voice too. But I think this stuff is awesome. And there's a true epidemic happening right now. Double the number of liability related lawsuits, just liability related. Doubling of the number of claims that are made to the insurance companies, and to really cover their losses. Most people will protect their business with liability insurance, and that's going to be their number one source of protection. But the thing is, we have inflation, the raising of prices, but you also have something called shrinkflation, which is half less chips in your bag of Lay's each year, where companies are trying to charge the same prices that they were, but they're cutting as many corners as possible to be able to do that. And the insurance companies are no different. The more their losses are, the more that inflation impacts them. They have to start adding more to their exclusions and things that they're not going to cover. And policies are changing at a pretty alarming rate right now. And people don't have anything close to the protection that they had 30 years ago from the same insurance policy from the same company. Besides that, they're also finding more and more creative ways to deny claims. So having a structure like this is getting more and more important, and paying for the real insurance that you think that you're getting, where you have basically no exclusions and it covers you whether it's a personal or business liability, is extremely expensive. Not only on a yearly basis, but when you're taking into consideration you're going to be doing business for like 30 years, it just doesn't make sense financially. And something like this ends up being a fraction of the cost of the insurance. And it offers some short-term benefits as well. I remember last time we were here, you had some questions for me, Stefan, and
Right.
do you remember what some of those questions were? I'd be happy to answer some of those.
We can get to that. I know you have like another slide we can look at maybe afterwards. But there's a question actually in the chat from Brent. So Brent is asking, should each multifamily property be in its own C Corp or a limited liability company?
Let's see. So Brent, are you talking about multifamily, like commercial multifamily, or are you talking about residential, like 4 units and under? Larger, okay. Yeah, those definitely need to be in separate entities, regardless of the capital stack. If you're syndicating it, if you're a fund, there's really no good excuse to not have every property in an LLC, especially with multifamily. You have a massive amount of liability exposure, and I'm guessing you're a general partner, which means you have close to unlimited exposure. So,
but then is there a single C Corp assigned to each of those property LLCs, so to say, in every case, or can you have one C Corp assigned to multiple properties LLC?
Yeah, one C corporation. C corporation doesn't hold anything. Remember, that's in the actual holding company, which is usually an LLC.
So the C corporation is still a single C corp for all of those.
Yes.
One for multifamilies. Okay.
Yeah. That basically allows all the income to go through a single entity. You get a lot of deductions, fringe benefits. There's a lot of things that C corps can do that no one else can do. But it's just keeps things simple for the entrepreneur. Everything goes through it into the holding companies with your pass through, and you can either do the Wyoming LLC or IDST, which is a intentionally defective revocable trust, intentionally defective grantor trust, and that's a type of asset protection trust that can also have profits passed through it. But again, I don't want to get too far into the weeds on that, so I just have the Wyoming LLC there because most people are familiar with that.
Right. So Judy is asking, would this also make sense for small companies, i.e., owning one real estate property?
Yeah. So I get that question a lot. When should I do this? When would it make sense for me? In law, there's something called a cause of action, which is something that happens that triggers a lawsuit, or at least could trigger a lawsuit, where the justice system provides a remedy for that claim or for that wrong. So if I go out and I hit someone with my car, that's a cause of action. They don't have to do anything about that, unless say they go to the attorney and they go to and say, hey, Riley hit me with his car. I want to file a lawsuit against him. And usually those personal injury attorneys are contingency based. And the way that they operate, they don't take on lawsuits just because they feel like they can win. They only take on lawsuits that are going to be worth the payout in the end. And if I have a $10,000 limit on my insurance, and the attorney does a public record search on me and they see that I don't own anything, they're probably going to deny that case. They're not going to take it on. And if down the road, let's say in a year or two, I acquire a few more rentals, that person can look at me and say, hey, Riley's got a lot more assets. It'll be worth it to pursue him now. If I went and did this restructuring right after I got in that car accident, and they see that I'm worth suing down the road, they can look back and they can say, hey, the cause of action or the time that the car accident happened was before he did all of this asset protection. And under the UFTA, that makes those transactions voidable and they can be reversed. So all of this structure, if I set it up after the cause of action, there's a good chance that it can be broken and reversed no matter what I do. And so it's really important for small businesses, if you can sacrifice the funds necessary to do this, it's really smart to do so because you have no idea when that cause of action is going to happen. And when it does happen, or when you think it's about to happen, the UFTA takes effect and those transfers and movements of assets can be reversed. So, like they say, the best time to plant a tree is yesterday. And the same thing goes for asset protection. The longer these entities are in these assets are in these entities, the stronger the asset protection becomes, and the harder it becomes to penetrate. Good question. That's pretty frequent one that I see. Do you recommend the LLCs be set up in the state the property is in? Yeah, you can do that. If you don't, you're either going to have to hold the property in a trust, which I would absolutely not do. If a trust makes over $13,000, it's taxed at the highest possible tax bracket. And so you either need to file a state LLC or a foreign LLC from another state. Either way, you're going to be subject to the jurisdiction of the property. So the state laws will apply whether it's a foreign LLC or not.
So
good questions. Yeah, go ahead.
Question I got from Rob he sent it to me. So how many tax returns for this setup, for the setup that you have, let's say in the chart, federal and state combined?
2. One for the C corporation and one for the client. Mm-hmm. Yeah, everything else is passed through.
Right.
Yeah.
Mm-hmm.
I mentioned the intentionally defective grantor trust. That's basically a irrevocable trust, so an asset protection trust, if you will, that is defective in the eyes of the IRS, which means it doesn't count as a standalone entity, and it becomes a pass-through entity, which is normally only reserved for revocable trusts, which offer no asset protection. So with that intentionally defective trust, you won't have to file an extra tax return. Yeah, this is pretty much a lot of people have S corporations, which I almost always advise against, but it's the same thing with an S corp. You're going to be filing 2 returns with those as well.
So, and you mentioned like short-term rental investors, like what would be a reason for them to use a structure like that versus, just any other real estate investor?
A lot of that comes from the C corporation. Short-term rental investors have a tremendous amount of exposure that they get exposed to. And, that has to do with a lot of people coming and going in their properties. The other thing is the insurance industry hasn't done a very good job of catching up with the short-term rental industry. And if you look at some of the case law, Moss versus State Farm is a huge one, where the defendant had a homeowner's insurance policy, and they were living in this property, house hacking basically, and they moved into their next property, but they left that homeowner's policy in place, and they did a short-term rental. I believe they only rented it once, and the person tripped down the stairs and filed a lawsuit against them, and they lost. And they went to file a lawsuit against State Farm because State Farm didn't want to cover it, and the reason State Farm didn't want to cover it is because it fell under the exclusions, which your primary residence isn't for systematic rental of real estate. And so their insurance didn't cover them, and they were on the hook for a massive amount of liability. And unfortunately, that's really common. So short-term rental investors having their lease agreements through the C corporation basically makes it an arm's length transaction, and gives them those benefits, but most of the liability will fall on the C corporation, which has no exposure. And they can file a lawsuit against the holding company, and they have a right to do that. You can sue anyone you want. But the further away you get from the original entity that they were dealing with, the more difficult it becomes to prove your case and prove that other party was liable. And there's more that you can do to protect yourself, but for short-term rental investors, this is huge. A lot of investors I see, the tax reduction alone is more than what this costs to set up. And usually something like this will cost between $8,000 and $12,000, depending on the complexity and how many agreements there are between the entities. how many assets we're transferring into holding companies. But typically their taxes are reduced by more than that in year one. So yeah, hopefully that answers your question. I'd say that short-term rental investors have more to gain from doing this than just about anyone else.
Mm-hmm. And so for this setup, like since you mentioned like 2 tax returns before, so Rob is asking, so the two federal returns, 1040 and 1120, and no state. Is that what you typically have for this setup, or is it a 1040 and 120 forms?
Yeah, almost all the income is going to go to the client on their 1040. Yeah. That's one of the things we do to try to keep it really simple.
Okay.
We can change that. Some people who are looking for financing are concerned about having so many items on their 1040 because it kind of intimidates lenders, because they have this, perfect box that everything needs to fit. And if you don't fit in that box, they'll deny the loan even if you're more than qualified. And so changing this Wyoming LLC into a partnership with the trust makes it have to file its own tax return. So that adds a third return. However, now everything is flowing to you on a single line item on the K1. So.
Mm-hmm. So Judy is asking, so is a family trust an option for someone who is single with no kids?
Yeah, of course. Anyone can have a trust with anyone. We call it a family trust, partially because everything you do, you need to do for estate planning purposes, and that helps with the level of protection. Because if you're doing it for purely asset protection, that can be seen as attempting to defraud creditors and is not looked upon very kindly. But we're not just doing that. We're doing estate planning and we're doing tax planning as well. So yeah, anyone can have one.
Mm-hmm. So I know you have like that bigger type of chart, or like collection of charts, I guess, on your LinkedIn, and also that you shared before. Do you want to show that slide as well, perhaps?
Yeah.
That had a kind of like asset protection and some other pieces to it, like the asset protection, tax planning.
I can pull that up. Yeah. I tried to kind of condense it on the website. This actually, makes reference to the statutes that it relies on, and there's a lot more information here than there is on that one.
Okay, I see.
But yeah, I can still show you that.
Mm-hmm.
Let's see. Oh, I think this is the old one as
right.
well.
Do you mind kind of zooming it out, I guess, if that's just to be able.
Yeah, let me just go right to my LinkedIn. I'm probably going to be updating it, but yeah, you're right. It has a lot of the info readily available. Oh, it's not coming up. Yeah, I can send it to you later though if you want.
Sure.
Should be right here.
I thought maybe in your activity, perhaps, or if you have it there, I guess.
No.
It's okay, no worries.
Sorry.
Sure. Okay, so in terms of, I mean, like the general, just for our audience, like the general distinction between like what is asset, I know you have like some of it here, right, in those explanatory kind of pop-up notes, but what is asset protection and what is tax planning, and what is the difference between the two, let's say?
Yeah.
Mhm.
Yeah, essentially, asset protection is everyone's right to defend what they own. And asset protection is a preemptive way of defending what you have. And so you're setting things up, you're putting your properties into LLCs, if you will, just in case something happens. And most people put them into a LLC because if you have something in another LLC, you don't want that liability to leak over to the other property and lose both properties, or to leak over to you personally and for you to lose personal assets to a lawsuit. Pretty basic stuff. It's, I would say, one of the #1 reasons why people get an LLC to begin with. Tax planning, on the other hand, is that preemptive defense, so to speak, but instead of the person coming for your retirement or your all of your assets, they're coming for taxes, and it's the IRS that is looking to collect those funds. And in the Internal Revenue Code in the IRC, there's lots of probably over 80,000 pages, and there's a lot of things that legislators have intentionally made possible that you can take advantage of and use if you know how. And an LLC, again, is an example of one of those. A family trust, that one of the main reasons people used to get family trusts was for the estate tax, or the death tax, as they called it, where when you pass away, anything that wasn't in a trust, the government would take 50% of. And that still exists, but instead of being a $600,000 threshold, it's 12.5 million, and most people don't meet that threshold. But yeah, you're just planning for the future. And unfortunately, a lot of accountants don't do tax planning because of this. There's a lot of legal involved with it, and accountants tend to be on the conservative side. They don't want to be viewed as giving legal advice, and they just err on the side of caution, and they more or less just try to make efficient whatever setup you bring to them, rather than trying to change the setup that you have. And so for that reason, I usually call accountants financial historians.
Right, I see. Right. So if I may interject, actually, like just to what you mentioned again, just for our audience. So the current estate tax, like what is the threshold for that one to kick in, and what percentage is it?
Yeah, it just changed. It's I think it just changed to 12.9 million. It was 12.5, and it's about 50% is what that tax is. So
it's an estate tax for anyone who dies whose estate is like bigger than 12.9 million, and 1/2, if it's not like structured in advance in the proper way, 1/2 of that would kind of go to the to the government, essentially, in that regard.
Yeah, as it gets transferred to the heirs. You also have transfer tax. Anytime a property is moved, it incurs transfer tax. But a couple of things. Moving a property into a living trust doesn't trigger those types of taxable events. And when you die, those assets are not owned by you, they're owned by a trust. And the trust didn't die. The trust doesn't pay the death tax or the estate tax. You do on what you own. And so by getting things out of your name and essentially not owning them and having a trust own them, you shrink the value of your estate, and you're less likely to be at that 12.5 million threshold.
And under the 12.5 or 12.9, there's no estate tax in that regard. So what kind of
no estate tax, but if you don't have a trust, your assets still have to go through the probate process. let's say you've got a bank account, a business bank account with $1 million in it, and it's your dad's, and he passes away, and you go to the bank and you say, hey, I'd like to access my dad's bank account. And if you're not a signer or authorized on that account, you can't just say, well, I'm his son, give me access to the account. You have to get a court order. And that court order is issued as part of the probate process, where the court basically decides what should be done with those assets. So you can't just, roam around willy-nilly, just claiming things just because your dad or your mom owned it.
Right. So
if it wasn't in a trust that you're the beneficiary of, you have to get a court order and have it approved by a court in order to take possession of it.
So, so let's say, would you say, like, I mean, kind of a simple question, but would you say like setting up a family trust or is sounds like a more efficient process than like the more your typical like people setting up a will, like writing their will for, like, what is your opinion on that process? Let's say simply writing a will and that way avoiding the probate process.
Yeah, it depends on the kind of will it is. If you're doing a last will and testament, which is what most people do, that document at the time of your death creates something called a testamentary trust. But for all the provisions in that will to be executed, that will has to go through the probate process. On the other hand, with a pour over will and a trust that you create while you're alive, a living trust, you move those assets while you have control of them, and you don't need a court's approval to be able to make those movements of assets. And anything that you forget to move can basically be covered. A pour over will gives blanket coverage to your assets, and it allows them to automatically transfer to your trust if you pass away. And you forget to
let's say, presumably, with the more efficient trusts chosen, one would still need a will to assign that trust to another party, or does it sort of, or is there no need of a will whatsoever, and there can be another setup?
Your trust document will lay out who the beneficiaries are, and the pour over will is used in conjunction with the trust just in case you forget to do something. But in an ideal world, you never have to use that pour over will. Whereas with the last will and testament, you basically have to get a court to go through everything and say what you can and can't do. So yeah, most trusts, if they're done for estate planning, have a pour over will to go with them, and then someone who usually it's their financial advisor or someone who tells them to do a last will and testament.
So
that works. It's just not the most effective or efficient.
Right. So what would be like some, you would say, like most common events that kind of, I mean, one wants to have like proper asset protection in advance, but like some most common events that would trigger, assets exposure. So let's say, a lawsuit is one. Okay, then you have on its own. Then you have also like debts, like kind of when you need to like do the trust with the proper trust with that additional will, perhaps, and so forth. And then maybe divorce is another. Like, what would be the main events that you deal with, let's say, with your clients?
Yeah. I mean, you're right. There's a lot of categories. I'd say torts are the most common, which is like slip and fall. Usually, it's in the form of personal injury, malpractice. those tend to be more frequent, but more so than that, the dollar amount is significantly more than other forms of lawsuits or legal proceedings that people face. And so I'd say that's the number one that people are afraid of and get hit by the most.
And that's, would you say that happens with short-term rental investors as well? Or
yeah, a lot of short-term rental investors, they're on Airbnb, and Airbnb has a program called Air Cover, which covers damages caused by tenants during their stay. But it doesn't cover anything in liability. And so if something happens in liability, and their insurance policy doesn't cover it, or the claim exceeds the policy limit, then yeah, they're going to be on the hook, and that happens more often now than at any other time.
So what, just like I have a couple of other questions, but let's say what would be your, I guess, advice or like things that you guys do as far as spousal relationships, let's say, like in the so for legal marriage, and then in the event the unfortunate event people legally separate, what would be the usual protection that one can set up in advance to kind of protect from losing, I don't know, unnecessary amount of assets in such case?
Yeah, it kind of depends on the form of ownership you take and who's on the document. If they're a 50-50 partner on all the businesses, and those businesses were created after your marriage, then they'll be able to claim those. But if you're the only person who is on the paperwork and who can sign for that company, who's on the bank accounts, and they sign a prenuptial agreement, then pretty much everything that you create will stay with you.
There is no special setup that is done in that case for spousal relationships, right? Because
for spousal relationships that are anticipated
that ultimately do not, that ultimately may not.
No, we've come across that like once, but the situation wasn't really unique. It's pretty rare for someone to be thinking this far ahead,
right,
and also expect their marriage to be ending. Usually their marriage is intact, or they're single and they have a business partner or something.
Okay, got it. And so a question I had from Mark on the chat. So what are the requirements to become a C Corp?
You just file for it. There's more requirements with an S corporation, but it's not the requirements aren't to become one. It's operating requirements, and so S corps have operating requirements, C corps have operating requirements, and ways that you're supposed to do things. And again, that's so that you can have the corporate veil protection honored by a court. So those requirements, so to speak, are the real requirements are in the ongoing operation, not in just becoming one.
Okay, Scott has a question. Go ahead.
Hey, Riley. So on the short-term rental topic, you mentioned there was a pretty famous case where someone had primary residence coverage, moved out, and then there was a claim against the property when they converted it to a short-term rental.
Yeah.
I'm just curious the way that it works. Let's say that happens, but the proper insurance was in place. So they called their broker, they got it set up to be coverage for a short-term rental, and then that same trip and fall happens. What situation would that person be in where that insurance would not cover them and this whole structure would need to kick in?
Yeah, I mean, if they have the correct insurance, or insurance that doesn't have that under the exclusions, then they basically would pay their deductible and then hope and pray that the cost of the lawsuit and the claims and everything don't exceed their policy limit. In this situation, what we're relying on two things for the protection: the follow through of someone keeping the corporate formalities so that the corporate veil will be protected, and filing these entities in states that have a really strong case law backing up the strength or the protection of these entities. And different states vary in their strength of protection and how frequent the court pierces the corporate veil. The other thing that we're doing is we're moving things out of the paper ownership of the person, which means on public records they look like they're poor. They don't look like they own anything. And when someone maybe files that lawsuit, they're more likely to just settle for the policy limits of your insurance company rather than going and trying to pursue you. Because two things: it's really expensive. They may not be able to collect on their judgment, and if they can't collect, the IRS sees winning a judgment as income. And if you win $1 million judgment, you got to pay like over $300,000 in taxes on that judgment, and those taxes are due the year that you get that judgment, not the year that you collect on that judgment. And so if they can't collect on their $1 million judgment, they're still on the hook for hundreds of thousands of dollars in taxes and the legal fees. And so there's a lot to lose by trying to pursue someone who looks like they don't own anything. And so most of the time those cases just don't even get filed to begin with. And so we just want them to take the policy limits of the insurance and be done, or just not bother you at all.
Well, that makes sense. Thank you.
Yeah.
So perhaps kind of like related to the same, like I have a question in terms of if you, so the general question where, let's say somebody purchases their first investment property and they are like contemplating whether to put it in an LLC or whether they may keep it under their name, but perhaps have like liability insurance, or perhaps have a whole umbrella liability insurance policy for, let's say, several investment properties. So what would you say is the protection of putting that property in an LLC versus the liability insurance or umbrella policy for multiple properties?
Yeah. So you're basically asking what's the protection difference between umbrella and an LLC?
Kind of, yep. Or just liability insurance for that single one property, or umbrella for the multiple properties. Yep. Mm-hmm. From a liability standpoint, either for the trip and fall cases that you describe or other ones.
Yeah. I'd say that the main thing is you never really know what your insurance company is going to choose to do, if they're going to pay out on the claim or deny it. If you're running an Airbnb in a part of a city that has disallowed it and considers it illegal, you could have perfectly legitimate insurance in place, but if they find out that you're doing something illegal, they can deny that coverage. And maybe you don't even know that policy changed. You could have no idea that you were doing something that's technically illegal. And if something kind of crazy happens and it falls under the exclusions, I have nothing against insurance in general. I think that it's really smart to have insurance, and you can get a pretty decent amount for not very much money. But to go beyond that that initial coverage and protection gets very, very expensive. Something like this is going to be less expensive. And so putting that property into an LLC will protect you, potentially from, an infinite amount of judgment. The problem is having just a sole LLC as your primary source of protection. And if someone comes after you, you still need to defend yourself, and it costs a lot of money to defend yourself. There's no contingency-based defensive attorneys because there's nothing to win by, or nothing to gain by winning. You just, the other person loses, but you don't really win anything. Just a huge bill, basically. And so it kind of just discouraging those lawsuits from being filed against you in the first place is the best course of action, and by far the cheapest, in my opinion. So yeah, I would say if you're going to do one or the other, probably umbrella insurance. This is more of like a plan B, but this plan B needs to be put in place as soon as possible. This isn't like long-term stuff. Like I said, that cause of action can happen at any time. An insurance company can deny a claim. And so if you can afford to do both, do both. And yeah, I mean, I wouldn't ever advise someone to do this instead of insurance. I just think they have to be done together. Yeah.
Right. And what about partnerships? So, for example, joint venture partners in an investment property, or general partners in a real estate syndication, for example. So you have like several co-general partners, and let's say on the unfortunate event, one of them dies, let's say, and what is a good protection that one needs to be thinking ahead before entering into those partnerships?
Yeah, the legal structure is important. In a lot of general partners that are set up, the general partners have general liability, which is unlimited personal liability. So I'd say that's a huge one. Another thing that I see pretty often is people trying to set up an S corporation as a partnership, and putting real estate in it, which is a mind-blowingly horrible idea. I still can't believe that some accountants advise their clients to put real estate in an S corporation. But yeah, if you do that, specifically with the S corporation, you can only hold those S corp shares as an individual. You can't hold them in a business trust. You can't hold them in another trust or an LLC. It has to be you, which really exposes you to the public. Another thing that a lot of people don't consider is with a general partnership, if one of the partners takes on a personal liability, they get sued or something happens, with some forms of ownership, they can transfer that liability onto you as their business partner. And so the person that you're going into business with, you very well could be sharing their liabilities. And a lot of that can be avoided by setting up another entity in between, where you have an LLC that's owned by either a couple trusts or LLCs other than your personal name, and that stops the liability from spilling over.
But then other than that, like purely one of the partners kind of like this dying, or just like no longer, let's say, developing a disability or whatever, no longer being able to be active in that the management of that company, let's say, is there any protection to that, or that's, I assume that's not an asset protection question?
Yeah, it's not, that's more of a business succession question.
Yeah. Okay, sure.
But you should have provisions for that in your operating agreement. And if not, then they need to lay that out in their will, or make you a beneficiary to specific assets in their trust, and hold the ownership stake in their trust. But yeah, a good operating agreement will make that a non-issue.
But from the kind of the trust and then will standpoint that you discussed before, like from that standpoint, that trust, like the terms of that trust and will that you discussed previously, they would be set up in a way that, for instance, ownership in all those partnerships would then flow into whoever you want to be the beneficiary of that trust and so forth, presumably, right? Such as if you have ownership in, let's say, multiple syndications or multiple JV projects. Is that the fair statement, or?
Yeah, I think so.
Sure. I mean, yeah. Okay. And you mentioned before, I think, like when we had like that previous discussion, you mentioned like there is a tool for, it's not, I don't know if it can be regarded as tax planning, like the deferred sales trust, right? For deferring taxation, essentially. So I know you mentioned like some considerations as to whether that would be legal now, or whether that could be perhaps considered legal in the future and so forth. And it seems like there is a debate out there if it's actually a legal tool that one should use. Like, what is your opinion on that?
Yeah, I think it depends on the influence that you have over the trustee and how your funds are used before they're distributed to you. I actually talked to Robert Binkley last week, and he's the inventor of the DST, the Deferred Sales Trust, not the Delaware Statutory Trust. There's two DSTs.
That's true, yeah.
The Deferred Sales Trust. And I have an appointment with his tax attorney to go over some of the specifics of what makes it legal or illegal. But Robert told me that they rely heavily on the Internal Revenue Code section 453, which is for installment sales, and installment sales are definitely legal. In their particular scenario, I think that the way that Robert does it is good. I don't think that the way that every company that offers the DST is good, especially if those assets are not exposed to any risk or invested in any way. Then it definitely is a problem.
Okay. So we're running out of time here. So we went over like a few like pretty nice questions.
Yeah.
So do you guys, any last question you guys want to ask?
Are you awake still?
So perhaps like what is
Thumbs up. Good.
Yeah. What would be the best way to reach to you? So you have your website up there.
Yeah. Yeah, I'm on LinkedIn a lot. Yeah, you can reach me on my website. I can put my personal information in the chat as well. But yeah, I mean, you can, my direct number is 406-250-1699. That's my old business number I've had since I used to live in Montana. I live in Arizona now, but yeah, you can reach me there and ask me whatever questions you want, and I'll sure help you the best that I can. I outsource to my partners to actually implement this, and they're attorneys and tax attorneys or accountants. But I definitely know the integration side, and I do know quite a bit about each side respectively. If we need to hop on a call with one of the attorneys, then I'm happy to do that too. But
Sounds good.
I'm pretty passionate about it. If you can tell, the fact that that small businesses are getting attacked, and the tax burden is increasing on them, and these predatory lawsuits are coming against them simply because of their inability to pay and their tendency to just capitulate and settle. They're just being exploited like crazy, and it's increasing quite literally exponentially. And
So that double increase in like the liability kind of,
yeah,
that's over what period? So that's the past 1 year versus the previous year, or
yeah,
versus,
that's 1 year they've doubled.
So in
Yeah.
2022 they doubled, or 2021.
2021, yeah. And those nuclear verdicts where the jury decides that there's more than $10 million worth of damages, which should not be as common as it is. The average nuclear verdict is $214 million. So well over 10 million. And yeah, I mean, people can't be expected to pay that, especially when us as entrepreneurs, we're creating jobs, we're creating housing, and for us to be the center of the target for free money, it just makes me so angry. And most people don't understand this, and their accountant is the person who gives them their information, but their accountant doesn't understand this either, even though a lot of them think they do. But they don't get trained on asset protection in accounting school or in their undergrad. They just kind of have to learn it on the job. And even if they do know how to do this, they can't help a client actually implement it, because it would be practicing law without a license. And so it just, business owners are just in a really, really unfortunate place, and a lot of them don't realize it. And yeah, this was started out as kind of a pet project, but it's becoming quite a passion for me. I want to see this change.
But once again, like if people like who are listening to this, let's say they want to do like few like very simple steps to reduce their asset exposure to kind of predatory lawsuits. So would you say like kind of keeping every business separate in its own LLC and placing that in C corps and a family trust, that would be like the general goal? Or like what would be like a couple of like very easy steps that they can take?
Your first two steps are to separate each asset, one asset per LLC, no matter how much equity's in it, and keep really good records in that LLC. Make sure that you have a board of directors. Make sure that if you have stock, that you're issuing it correctly, and that you're meeting at least once a year, and that you're not commingling funds. If you do that and you really act like a business, you start with seed capital, investment capital, and the business has an active purpose in the marketplace, and it's not just a holding company. And I mean, on the website you can kind of learn about more of this, but we don't set these up as basic holding companies. These are intended to have an active purpose, and having an active purpose, a business plan, and again, really acting like a business, and keeping a record of it is going to protect you a lot. It'll protect you quite a bit. Yeah, unless you're in California, unfortunately.
So that would be like kind of the main thing. So just separate LLCs for every asset and like really good records, kind of bookkeeping and kind of actual business behavior there, if you will.
Yeah.
Mhm.
Yeah, just try to not hold assets in your own name. Yeah.
Right, and to people who already, I do, for example, I own some real estate in my name. So let's say, what do I do? Do I don't know what the advice that people give online to kind of do a quit claim deed to an LLC, is that a sound advice or?
No, it's not.
Okay, so what would be the way
The
to
best,
go about
best
it?
way to get it out of your name is an inter vivos transfer, which is moving it into a living
What
trust.
transfer, sorry?
Inter vivos, INTERVIVOS. It's when you move personal assets into a trust, a revocable trust that you control. That's one of the easiest
You
ways
just
in
move to
every state
an
that
LLC.
bypasses the transfer tax and all that. What was that?
I'm sorry, yes, sorry to interrupt. If it's not moving to a trust, but you just move them to an LLC alone. So you have it, you own it as an individual, you wanna eliminate that liability, you move it to an LLC, so limited liability company, like would you need an inter vivos transfer, or it's just whichever other ownership transfer you do?
It depends on the state. Inter vivos trusts are used a lot because they bypass the due on sale clause. It's actually illegal for a bank to call a loan if it's an inter vivos transfer. And you can assign the LLC as the beneficiary of that trust after the transfer. And at that point, the LLC effectively holds it.
I see. So that is the way to actually to bypass the due on sale clause if you have a mortgage.
Yeah.
Okay, got it. Understood. Okay, so thanks, Riley. That was very informative, I think, for everyone. So
Yeah.
appreciate it. And so once again, like, so your company, so Flying N, right? Flying N, flying-n.com is your website. You're on LinkedIn as well. You share your phone number too. So yeah, hopefully, I'm sure some, many people would be interested to even we'll be reaching to you. So yeah, so thanks for all the information tonight, and it was a pleasure to have you here.
You bet. Yeah, anytime. Thanks.
Yeah. Thanks to everyone. Have a good night.